people are interested in because the law is a little unclear on landlords' rights. And there has been a lot of press on this, and I wanted to really get one of my experts to talk about this subject. It's something that people are asking us all the time as to what exactly tenants can and cannot do and how this is all going to pan out. So I'd like to introduce you to Daniel Flynn, who is a barrister, who is also a solicitor and a solicitor advocate, and he's a partner in our dispute resolution department. So he specialises in property disputes, both family and inheritance, and of course landlord and tenant. So over to you, Daniel.
Hi. Hello everyone. As Vinay says, my name's Daniel, and I've slightly drawn the short straw because it's now been 10 weeks since I've been able to get a haircut before I do this webinar. And before we start, as we've done with a lot of these, I wanted to ask a quick poll question. It's not strictly to do with landlords during the lockdown, but more generally to do with residential landlord and tenant, buy-to-let landlording, and managing your property. What is the most important document that you need to have sorted out when it comes to dealing with the tenant in your property? Should have just launched the poll there, so if you want to vote on that, then that's... Yeah, there you go. Wow. With quite a few results in, I'll just the results of that. There's very, very strongly in favour of the tenancy agreement. Certainly, it's important to make sure that your tenancy agreement is correctly dealt with and is clear, is in the up-to-date format, and is compliant with the law and regulations. But recently, a document that's been almost more important is the gas safety certificate. Now, the Deregulation Act changes that came into effect in 2018 mean that unless the gas safety certificate was served at the beginning of the tenancy, it's arguable, and it hasn't yet been cleared up by the court, that this should mean that the tenancy, it's effectively impossible to end the tenancy unless the tenant does something wrong. It's not strictly to do with the topic of my talk today, but it's something that is coming up really frequently as I deal with residential landlord cases, and it's really important to bear in mind that the gas safety certificate is can almost by accident grant indefinite security of tenancy to a residential tenant. Just to worry everyone before we start. Now, I've been asked to talk in these uncertain times about what landlords' rights might be during this lockdown period. There's been a lot of talk in the media, in government, and through the financial sector about the problems that people who are renting are facing, the problems that people who are paying mortgages are facing, and the problems that the financial sector is facing more generally. There have been a few changes to the law that have been brought in, but not as many as you might think from the amount of column images that this has been generating. And so we'll go through some of those today and then take questions at the end. There's a Q&A function built into the Zoom meeting, which my lovely assistant, Mr. Tanner, is going to be looking at throughout this talk. So, broadly, as everyone I'm sure knows who deals with buy-to-let property, the situation remains as it has always been. The first point to note is that you still need a court order to end a tenancy. To try and end a tenancy without court sanction or full agreement from the tenant is still a crime under the Protection from Eviction Act 1977. Now, the processes, there are two main processes for evicting tenants. Those are under Section 8 of the Housing Act, where there's been a problem with the tenancy and we're saying that the tenant ought to be booted out by the court because they've done something wrong, or because of the slightly more technical grounds under Section 8 regarding mortgages or property that's been let out on the basis of an ecclesiastical role linked to a church, for example. That's a more challenging route to go down to get a court order. And so the usual route for seeking possession of the property with the normal situation is under Section 21 of the Housing Act 1988. That means that's what was usually referred to in the press as a no-fault eviction. All that's required is to serve notice and make sure that the tenancy has been dealt with correctly in the whole course of the tenancy. So the gas safety certificate has been served at the beginning, as I mentioned, and then the deposit's been dealt with properly, the energy performance certificates have been dealt with properly, the how to rent booklet, which is produced by the government, has been provided. Once, in order to end a tenancy under Section 21, the normal rule is that you need to provide 2 months' notice. Some other notices in which you would end a tenancy under Section 8 of the Housing Act or some other grounds have got different notice periods. So it's 2 months for a no-fault eviction, 2 weeks for an eviction where there's arrears of rent, 2 weeks notice where there's an eviction on the basis of other breaches of tenancy. And it depends on the specific circumstances of the case what the appropriate notice period is. All of that has changed during this coronavirus pandemic. The first step that the government took towards providing some further security for tenants renting property during this period is a change to the law which states that any notice serving on a tenant that requires them to give up possession of the property must give them 3 months, cannot expire before 3 months have elapsed. So that's Section 21 notices are now extended by an additional month, and that applies to any notice served between 26th of March and 30th of September 2020. So it's important to note that notices can still be served, proceedings can still be started. This change didn't stop you from doing something with regards to evicting tenants, but it extends the required notice to 3 months as opposed to the notice periods normally set out in law. Once that notice expires, as I mentioned, you still need a court order to end the tenancy. The way that you would obtain that court order is applying to the court under Civil Procedural Part 55. That is where the next change to the process of dealing with residential tenants has come in. So, on the 27th of March, the court rules were changed to add a delay of 90 days to any possession proceedings except for certain very niche cases, so injunctions relating to squatters, cases regarding trespassers on property. So all cases in the usual run of things where it's under Section 21 of the Housing Act and seeking possession of a residential property in the normal way will not be progressed through the court at all for 90 days from 27th of March 2020, so expiring on the 26th of June 2020, wherever they're up to in court. So that means that cases that we've had already running, we've received notice from the court that they have been paused. We haven't yet received any notice as to what's going to happen when that pause expires. No doubt the courts will be dealing with this in due course. The way that they phrased it in the court means that the proceedings are stayed rather than suspended, or the technical points of the court drafting effectively mean that you can still make applications to the court and you can still start proceedings off, but nothing will happen until on or after 26th of June 2020. Now, the last point in this slide is more of a point from experience than from the new legislation. When things do open back up, the delays in the courts are going to be extreme. As it stands, the normal waiting period from making an application to the court and then having the defence and then the court doing something with it might have been a month to 6 weeks before the coronavirus situation broke out and the courts shut down. When things reopen, I should be very surprised if it's less than 2 months between making an application to the court and hearing anything from the court, much less having an order for possession. So it remains to be seen what, if anything, will be done about that. The court is talking about extending sitting hours and extending the availability of judges, but they've said a lot of that before without actually doing anything about it. capacity in the civil courts to deal with these sorts of cases, unfortunately, it's extremely limited at the moment, and it delays the norm rather than the exception. So the two main actual practical changes that government have made so far concern the notices for possession and the stays in the court, both of which focus really clearly on ending tenancies. And it's clear what the rules are with regards to those ending of tenancies. So far, despite a fair bit of chat in the media and in government as to what other practical help might be given to renters or to landlords, there's not been any practical changes to legislation, and there's not been any other practical steps taken whatsoever beyond those available to all small businesses, and if you're running things for a business, and all private persons for example, furlough, job retention schemes, and self-employment income support schemes. So something that a lot of people have been asking about is whether or not they're obliged to do anything about rent. A lot of tenants have been asking about rent reductions during this period as they've been struggling to pay rent. Perhaps jobs have become difficult. Perhaps people have been who are self-employed in particular have been finding this an extremely difficult period to find work and to earn money. The government's massively helpful comment was that there was a recommendation that there should be a discussion in good faith between tenants and landlords. That is obviously of limited utility practically, because rent needs to come in, mortgages need to be paid, costs need to be paid, life needs to go on. The starting point, as I put in the middle of this slide, is that the tenancy is a contract and the contract remains effective. Nothing so far that the government has done or that the courts have done, or the facts of the circumstances more generally concerning the coronavirus outbreak, would affect the fact that a tenancy is just a contract. It contains obligations on the landlord to provide the property and permit the tenant their quiet enjoyment of the property, and it contains obligations on the tenant to pay rent each month in full. There's nothing has changed that, and there's no obligation to offer any waiver of rent or offer any reduction. With that said, obviously a lot of people will be thinking about their tenants who are having difficulty in paying, and will be having both from the point of view of wanting to help people, and from the point of view of the commerciality of the situation. It might be difficult to re-let an empty property at the moment. It might be difficult to, it is difficult to go through the courts at the moment. It's going to be quite slow if you're going to try and evict somebody from on the basis of their inability to pay rent. One option which would sort of manage the situation would be to defer part or all of payment of rent. So if you came to an agreement with your tenants that they could pay a reduced rent for, I don't know, a couple of months now, while the impact on incomes is at its height, and that money would be, perhaps recoverable not before the end of 2021 or the end of the tenancy if earlier, then that would help the tenant perhaps maintain their situation during this period where there's a lot of difficulty with incomes. It would help the landlord maintain a good relationship with that tenant, and hopefully maintain a tenant who's in general terms a half decent tenant, rather than being trying to rent property at the moment, which is going to be very difficult on a commercial basis simply because of the restrictions that are in place on the market, as I'll talk about in a moment, but would mean that you would eventually get the money back one way or another. Any such agreement should be made in writing. The alternative is that you can agree to waive a period of rent or reduce a period of rent, and that's obviously an option that's open. But you may wish to agree to that with a tenant if that's something that can be agreed between you. There's no specific requirement as to how that should be dealt with, but from a solicitor's point of view, get it in writing and get it absolutely clear what the reduction might be, what the terms of that reduction are. So if it's going to be repayable at a later date, what that later date is, and if you can, perhaps mention in any written agreement what might happen if they don't keep to that written agreement. so that you could effectively use that as a break clause of a tenancy if that comes up in the future. And it doesn't have to be in, you know, a formalised signed contract. It can be in an exchange of emails, but it should be written in writing, because the problem will be otherwise a dispute in the future where there will not be an agreement as to who said what, and the court may say what you said is possible to have been interpreted as I agree to waive the rent for April, May and June or something, and that would leave you in a very difficult position. Even if that's not what you meant, it may be that it was possible to interpret it that way. If there's any doubt whatsoever, then talk to a solicitor who specialises in residential landlord and tenant litigation, such as myself, and we can help you to draft something that can perhaps be a blanket response to your tenants, or something more bespoke for a specific set of circumstances. You might also be thinking about how you're going to mitigate some of the costs if you do offer a rent reduction, or even if you don't, just because business is a bit tight at the moment, or if because a tenant has left and so there's a bit of a void period. The other practical step that the government has taken, which is not specifically to do with rental income, but will affect all of the people who are running buy-to-let properties, is that the government has mandated that banks should offer a mortgage holiday to people who are going through a period of financial instability or financial problems due to the coronavirus outbreak. Now, obviously, that's quite vague as to what that should be, but it's been our experience that that has been interpreted by the various banks as if a tenant is unable to pay due to the coronavirus, then that can be interpreted as meaning that the landlord is having financial difficulty because of the coronavirus, and that can be grounds for them to grant a mortgage holiday. A mortgage holiday obviously comes with its own issues. It means that you probably extend the term of a mortgage. It means that interest is still accruing during the period that mortgage holiday is in effect. It might mean that you've got more to pay off on your mortgage. It might mean that you've got to pay your mortgage for longer, and it will mean that you'll end up having to pay a little bit more in terms of the interest that's accrued but not paid off. So it's not, you know, free money. It is an option for reducing overheads and maximising cash flow during a particularly difficult period. The other thing, which I haven't mentioned specifically on the slide, but which might be open and will be on a case-by-case and very specific basis, would be where you manage your portfolio of properties, or even just the one property, through a company. You might wish to explore whether, with your bank, whether the company is entitled to a business interruption loan or to a bounce-back loan, or one of the many other quirky financial products that have been supported by the Bank of England and by the Treasury during the coronavirus outbreak. These are usually only available to companies, but it may be that they are something which a company can access in order to support a void period of rent, or generally to support running costs for a company. And I haven't seen any literature on this myself, but it's not clear whether or not managing property would also count as self-employment for the purposes of the government's self-employment grant management scheme. You might wish to explore that as well. If you've got tax returns for the last couple of years showing that your primary source of income is from managing property, then that might be something that might be of use to you, and that's actually a grant, so that literally is free money. But there's a list of mortgages here. These slides will make available after the webinar, and these are just some of the various mortgagees and what they're saying in regards to buy-to-let payment holidays. You see that Barclays are not up for it, but most of the rest of the mortgage providers do seem to be at least willing to consider a payment holiday on a buy-to-let mortgage. So, as I mentioned in a previous slide, the contract remains in place between you and your tenant. That means that your responsibilities to the tenant are still the same during the lockdown. As a landlord, you must still keep properties safe and free from hazards, deal with repairs, especially urgent repairs. There's guidance as to how that should be managed if people are high risk or self-isolating, but ultimately, as with a lot of the guidance on the coronavirus situation, it comes down to the individual landlord who is going to have to make a decision on the balance of risk of is somebody self-isolating? Is somebody at high risk to the coronavirus? For example, if they're older, if they have a serious health condition, or what's the risk of the issue that's arisen with their property? Is it something that must be sorted out immediately? Is it something that could be put on the back burner? That's going to have to be dealt with on a case-by-case basis. There's limited precedent on that, obviously. The word unprecedented is getting bandied around left, right and centre at the moment. For us lawyers, it really does mean something. There is no precedent on a lot of what's happening, so we're having to work out from first principles what's likely to be the court's view on various cases. So the things that still need to be done include dealing with gas safety certificates and gas safety checks and making sure that those are all up to date. Still dealing with energy performance issues if those aren't up to date, although those are a lot longer and less of an issue if they're not done. Protecting deposit schemes, ensuring that tenants still got right to rent, and still ensuring that the how to rent checklist is dealt with, and everything that would otherwise be in place outside of a global pandemic. So what happens if, despite all of this, the tenant does have to move out and you need to get new tenants in? Since the 13th of May, there's been a bit of a change in how that's viewed, and it was always the case that under the Coronavirus Health Protection Regulations England, Regulation 6, that you could move house if it was reasonable. The government has emphasised that more since the speech on whenever it was, the speech by the Prime Minister. And it's since 13th of May been changed so that now, as well as moving house, estate agents can now do viewings, conduct viewings, potential tenants and potential purchasers can conduct viewings of properties. That must be done in accordance with the usual rules. So you can't let yourself into a tenant's property without their permission, and you must give them a reasonable amount of notice if you're going to go round to their property. In HMOs, you can let yourself into the shared areas, but can't let yourself into private bedrooms. And that must also be carried out in consideration of the more general guidance that's come out about people's health at the moment, about maintaining social distancing and about maintaining proper standards of cleanliness and hygiene. And it suggested that estate agents and that landlords should be very careful about this. Again, to use the U word, it's unprecedented as to what would happen if somebody carelessly caused or recklessly caused infection of coronavirus. It's unlikely that that would be actionable, but it's the first time that we've really had to deal with this. So, but the short answer is that yes, you can now try and arrange new tenants, and that things gently should be moving back towards a more normal set of circumstances. You should, in the sort of fairly near future, be able to operate in a more normal way in regards to residential buy-to-let and letting property. So that's the end of the prepared remarks that I've got. And I'll now go to any questions that anyone might have. I think the way to do that is through the question and answer box.
Thank you. I've got a couple of text questions. If I can just
Yes.
start putting questions on Q&A. Please feel free to do so whilst we just deal with some questions which I've received in text in advance. So, what's the situation with regard to scrapping the Section 21 notice? Because it was a pretty hot subject pre-lockdown. Where are we on this?
Before, at the beginning of this year, the end of last year, the government had, quite out of left field, started suggesting that they might remove the option of a no-fault eviction, that they might end Section 21 notices. In terms of letting property, it's a relatively new invention, and since 1989, and the government was saying, well, we might get rid of that, so that the only reason that you would be able to end a tenancy would be if the tenant was in breach of their tenancy. So currently you can do that under Section 8 of the Housing Act 1988. So if they're in arrears of rent, if they're damaging property, and otherwise the tenant can remain there as long as they like. To be honest, that idea had not really been properly fleshed out. There are a lot of practical issues that would need to be considered just in the technicalities of how a tenancy agreement would have to be a totally different relationship between landlord and tenant without the access to Section 21 process to end a tenancy. and it hadn't really been given sufficient thought. I haven't heard anything about that for quite a few months now. It's certainly not been in the discussions about housing law that have come up in the course of the coronavirus situation. And I think that that's something that was only ever a very quite a vague idea from government on that. It remains to be seen if that comes up again once things have quietened down, but it never got to the stage of there being a proper a proposal that worked through any of the issues. It was more a kind of, what if we got rid of Section 21 no fault evictions? And it's like, well, there's a lot of questions that would come up and none of those were really addressed. So for the moment, and for the foreseeable future, I'd expect that you'll be able to use the Section 21 process.
So one other question, which is really related to the commerciality issue, which is, so obviously there was always this, this scheme that tenants used to get council housing, which was effectively to get kicked out of their private rented accommodation and then get onto the council list. And that was notoriously done, and it forced landlords to go through this pretty laborious and grinding legal process of eviction. Because of course the tenant couldn't actually leave the property because they would make themselves intentionally homeless. So this question, which is quite, I think is really pertinent, is if the tenant stopped paying rent because of their financial difficulties, the landlord commenced Section 8 proceedings. How? I mean, this is more of a sort of how do the council would see this, because clearly we're in an extraordinary situation. So are they going to be favourable to this, which will encourage more people to become delinquent with their rents, or worse, they will just simply try and do very little to cooperate and try and get a council house, and the council will see this as not being intentionally make themselves intentionally homeless?
I think any answer to that question is going to be framed by the fact that it's been, certainly in my experience with all of the councils that I've run across, their goal is to set the bar for getting a council house as high as possible, and to make it as difficult as possible for all of the parties involved to go through the steps. So they regularly advise tenants very enthusiastically about resisting possession proceedings. They will draft notices resisting possession proceedings to tenants, and in particular on the issue of Section 8 as to breaches of tenancy, I think councils will be extremely enthusiastic to support tenants in objecting to tenancy agreement repossession proceedings on the basis of any difficulties that have arisen from coronavirus. With that said, the law hasn't changed, so no fault eviction, apart from the extensions of notices and the extensions of time that I've mentioned, the court must still order possession on Section 21 process, and then what the council does after that. I mean, the tenant, whether or not they're getting a council house, is entitled to defend the claim. They're entitled to wait until there's an eviction notice before they leave, and but they will eventually have to be evicted by a bailiff, and that will still happen under the Section 21 process where there's no need to provide grounds. Under Section 8, if the mandatory ground for possession, so if the tenant is more than 2 months in arrears if they pay monthly, or some other periods if they pay by like rent quarterly or whatever, then there's some slightly different periods. But for a normal monthly tenancy, if they're in arrears of 2 months or more, the court must evict them. There's no discretion available to the court. Where they're in less than 2 months arrears, or where they're persistently late, there is a discretion available to the court, and the court is likely, I think, to exercise that discretion more sympathetically, while the tenants are pleading that their income has been affected by the coronavirus, and that once it all passes, they'll be able to get back on their feet and pay off the arrears. I think it's likely the court will be sympathetic to that. But I mean, commercially, if a tenant is in less than 2 months arrears of rent, probably don't apply to evict them in any event, because commercially it's going to cost you more in legal fees that are unlikely to be recoverable than a month and a half's rent is ever likely to get you back. If we're talking about commerciality more generally, it's almost always like the court has discretion on some of these Section 8 grounds, but doesn't have any discretion to order or not order an eviction when it's under the Section 21 no fault process, where the tenancy agreement has come to an end, or where a break notice a break clause has been exercised. And it's almost always more commercial to go under that Section 21 process, even knowing that you might not be able to recover any arrears of rent. You won't probably be able to recover any legal costs, and you'll have to spend a bit of money, because what you'll get for that money is a much quicker order, where there's no discretion available to the court. You'll be able to get the tenant out within a much truncated period, and you won't have to argue a case before a judge.
Just in terms of if the landlord's hand is forced and proceedings have to be issued for recovery, what's your timescales on this during this lockdown period with your experience with the courts?
In terms of recovery of unpaid rent just as a money claim, it's quite delayed at the moment, but it could be sort of 2 to 3 months before we get any sort of timetable for dealing with that, I think. In terms of either Section 21 or Section 8 proceedings for recovery of possession, nothing will happen until the 26th of June. Once things start happening on the 26th of June, I would estimate that it will be, if we've issued our claim before the 26th of June, I'd estimate maybe probably sort of 2 months before it's considered by a judge, and a judge will then look at the papers and decide what the next step is. So if it's Section 21, then they would say potentially decide on the papers and just give a possession order right there. If it's Section 8, then we'd need to prove our case, and so the judge would give directions for evidence. So that would be witness statements, rent statements, and a history of the ownership of the situation, the issue that we need to prove.
And the courts are obviously dealing with matters by video now, so those Section 8 hearings can be done by video conference. Is that right?
Yes, the courts are slowly but surely embracing video conferencing. It's
yeah. And the other question is in terms of bailiffs. Are they? What's the situation with bailiffs? Are they under lockdown as well, or are they being released from lockdown? Do you know?
It's bailiffs technically come under the same jurisdiction as the court process, so they are at the moment stayed, and all applications for bailiffs are stayed by the same thing that's staying proceedings for 90 days until the 26th of June. Once that is released, I expect that they'll start working again. I mean, it's a job which you can't do working from home, so they'll probably need to pop out and do it.
So we've got a question from Harry Sohal from Monarch Residential. Harry, so he's saying, is there any option to speed up the eviction following receipt of a judgment order? Bailiffs are on backlog all the time. So we've answered sort of that. Do you know Brentford, how Brentford's doing? Any idea? Because that's our local court.
It's usually taking about 2 to 3 weeks to a month to get, between 2 weeks to 4 weeks to get a bailiff appointment from Brentford at the moment, once you make the application, so once the order is expired. In terms of options to speed the eviction up following receipt of the judgment.
I know that Brentford
really
is actually closed, but at West London, all the stuff is going to West London, so I know that's happened. And then can a tenant request to set aside an order and money claim following a judgment order? I mean,
so it's a judgment, and as with any judgment, it's possible to apply to appeal it. It depends how it was granted. So if a judgment in a Section 8 case has been granted following a hearing where a court has heard evidence from both sides and then made a decision, then the tenant can appeal and they can ask for a higher court to make a decision. It's extremely unlikely that would be something the court would be very interested in. So the process would be that probably the tenant wouldn't even have to engage the landlord. So they would have to ask first for the court's permission to make that appeal. And I can't see a reason. I mean, it depends very, very, very much on the specific circumstances of the case, but I can't see a reason why that would be given if the court's heard evidence from both sides, especially if it's in a situation where there's arrears of rent. It's a mandatory jurisdiction for the court. So what that means is if there's a certain amount of arrears of rent, then just the court must make a certain order. It's not a determination that the judge makes.
We're just coming to an end. Just a couple of quick questions.
Yeah, sorry, there's a couple more questions. Landlords issuing Section 13 notices to increase rents. There's nothing has changed that jurisdiction. So the notice is on that. It's not a possession notice, so it's not affected by the change in the rule to extend the possession times to 3 months. So the Section 13 notice jurisdiction remains the same. And you can still go and serve them. We still have process servers who are going to view property, to let property and serve notices at properties. And there's no reason why you can't use the Section 13 process to increase the rent should you so wish.
Sandra from Castor Bay Property, thanks for coming on board. Sandra, you've got a question relating to the physical viewing. It's more sort of the practicality, but is there rules about that?
I mean, there's no reason why not. Absolutely, you can absolutely let a property, even if you haven't physically, even if the tenant hasn't physically viewed it. There's nothing preventing that from happening. You can still enter into a contract. My one slight concern would be with regards to the distance selling regulations. So there's rules about services over the internet. No doubt a lot of agents will know about these because they have a lot of their contracts over the internet. Those rules include cooling off periods that are prescribed by law, and in those cooling off periods, either party can decide that they wish to not have the contract go ahead. Now, how that would apply to a tenancy agreement is not something that's ever, or at least it's not something that I know off the top of my head whether it's come up. The reason being that it's usually people go and look at the property. Whether or not that's something that has come up is certainly something that I'd be interested to look into. But I don't know of any precedent on that point. I'm saying unprecedented a lot at the moment. But it's certainly practically and legally, there's no reason I can see which would be a problem with that. One thing that has come up during this lockdown is that the court's guidance is much more enthusiastic towards e-signatures and finding that electronic agreements to things are binding. So that's was pretty much sorted anyway. But sometimes occasionally would produce a slightly arid procedural argument, and that's been something that the court's taking a more enthusiastic view of.
Right, we have to come to a close. Time is ticking on. Thank you, everybody. I know there are quite a few questions people want to raise. Please do direct them over to Daniel. Actually, I've got Pavan Chowdhury from Woodland Estates. So perhaps he can. Do you want to say anything, Pavan? Well, he says that letting without a physical viewing is not best advised. A physical viewing will always cover any possible issue post-moving.
Yeah.
That's absolutely right. You certainly save a lot of lawyers' costs because you'll get yourself into such hot water afterwards of what's included, what's not, and all the rest of it. So, yeah, good point, Pavan. Right, so we have to wrap up. Thank you, everybody, for coming on board this very, very hot afternoon. And please send any questions to Daniel. We'll send a recording for those who weren't able to attend. And if you want a recording, please send us an email and we'll send it to you so you can forward it on to your contacts. Next week is assets abroad. Can you make a will for those assets which are abroad? So really interesting subjects. We carry on the Wednesday, every Wednesday at 3 p.m. Thanks, everybody. Have a great afternoon. Thank you, Daniel, for a fantastic talk. We'll see you soon. Bye-bye.
Bye.